אז שלום לכולן ולכולם. היום אנחנו פותחות את שבוע 13 של עיניים על עזה, ומתכנסות שוב כדי להפנות מבט ישיר אל זוועות עזה, לשאת עדות לה, וגם לסרב לנרמל את התוקפנות הישראלית ואת ההשמדה השיטתית. כמו שאיילת אומרת, המפגש שלנו הוא שילוב של למידה ומחאה. בעצם עצם הלמידה, הדיון והארכיון של ההווה שנבנה כאן, בזכות מי שמצטרפת אלינו וכל מי שמגיע לשוחח, ללמד ולהפנות את מבטנו, כל אלה הם פעולות של מחאה שמבקשות לערער על מנגנוני ההכחשה וליצור מרחב קולקטיבי של סירוב. היום תפנה את מבטנו מרחוק ממלבורן שבאוסטרליה, פרופסור שירי קרבס מבית הספר למשפטים באוניברסיטת דיקן. שירי מתמחה בין היתר בקשר שבין משפט וטכנולוגיה, והיא תשוחח איתנו על לוחמת מזל"טים ועל האופן שבו הטכנולוגיה מעצבת לא רק את טקטיקות הלחימה של הצבא הישראלי, אלא גם את התפיסות התרבותיות והמשפטיות שלנו ביחס למה שמתחולל בעזה. שירי תדבר במשך 8 דקות, ולאחר מכן נפתח את הבמה לדיון. כתמיד אתם מוזמנות ומוזמנים לכתוב שאלות בצ'אט, ואני אקריא אותן לשירי. ההרצאה תתקיים באנגלית, אתן יכולות לכתוב את השאלות שלכן גם בעברית. Shiri, thank you very much for joining us today, and the floor is yours.
Thank you so much. So before I begin, I would just like to acknowledge that I'm joining you today from the unceded lands of the Wurundjeri people of the Kulin Nation here in Naram, Melbourne, and I pay my respects to elders past and present, and to all First Nations peoples. Now, by acknowledging country, I also acknowledge and honor thousands of years of Aboriginal knowledge production, and I recognize that struggles for justice and self-determination are not just matters of history, but are ongoing. And in our discussion today, I therefore ask you to review core legal terms such as sovereignty, borders, self-defense, war crimes, civilians, genocide, from a broader lens than what current international law and its flawed institutions offer. So instead of a technical discussion of the correct legal interpretation of genocide or ethnic cleansing, I would like to use the time that I have today to consider how these legal terms are modified and recalibrated through advanced military technologies. And specifically, I point to the roles played by drone swarms in deepening processes of dehumanization that enable and legitimize the destruction of Gaza and the Palestinian people. So due to time constraints, I'll focus on 3 elements in the techno-legal architecture of the destruction of Gaza. First, I'll explain how drone technologies generate an avatarisation of Palestinians through digital specifications and digital sensing. Then I will explore the recalibration of international humanitarian law through drone swarms. And third, I'll consider the effects of drone mimicry of human capabilities and performance on the destruction of Gaza. So let's start with the avatarisation. And by avatarisation, I refer to the way military knowledge production practices generate and interpret information about individuals during armed conflicts. The transition from human-centered collection and analysis of intelligence to automated, AI-powered predictive intelligence means that individuals are reduced to variables that can be easily coded. People are seen through technical lens that reproduce them as something similar, but not identical to who they are. So for example, infrared lens allows better vision for nighttime operations, but at the same time, it does so at the expense of color detection, which may be crucial in armed conflict scenarios where some protected symbols, like the Red Cross, for example, require color detection capabilities. Another example that is inherent to drone surveillance is the separation of image and audio, which changes how our brain processes and interprets what we see. Of course, the vertical lens in itself changes our view of the world, offering more limited capability of detecting someone's height, for example, which may change our ability to distinguish between children and adults. And finally, some technical specifications generate dehumanization through inhuman data, like using temperature signatures or movement signals to reflect the presence of individuals, or through inhuman calculations, such as anticipation that 3.7 people may be killed as collateral damage, as 0.7 person is, of course, meaningless. Now, the second element that I mentioned is the recalibration of international humanitarian law. And by recalibration of IHL, I refer to the way military technologies and drone swarms change core practices concerning the application of IHL and compliance with IHL. And while we are concerned with the technical elements in legal definitions and how courts may interpret them or have already done so in the past, compliance practices with these definitions make these discussions, at least to some extent, obsolete. So let's look at the precision paradox, for example. The precision paradox is when the use of more precise or sophisticated weapons system doesn't actually reduce harm and may even intensify the destruction. Now, this is because the use of precision weapons, including reliance on drone swarms, generates numerous targets and legitimizes the violence that they cause. This relates also to algorithmic error rates, as even if the error rate is low, the fact that it also enables unparalleled generation of targets means that there are by definition many legal by designs errors. So we know in advance that there'll be plenty of errors, even if they're, if they're a small percentage, we do allow for much larger scale of operation overall. And so this, of course, drives significant escalation of the violence and destruction. And additionally, the use of constant surveillance for threat detection results in practices that generate humans as threats and present their elimination as both urgent and necessary. In the context of targeting decisions, for example, drone swarms and AI-powered targeting tools generate a move from few to many targets and from high to low-level targets. And this process legitimates more targeting operations and by definition tolerates more collateral damage as acceptable, simply by the rise in number and scale of legitimized operations. Now, finally, the third element that I mentioned concerns swarm mimicry of human performance. So drone swarms are designed to mimic human capabilities and performance and to generate human-like practices that are faster, stronger, at larger scale, or that analyze more data. These military advantages in response time and in data analytics capabilities come at a price. We lose and even devalue unique human capabilities. Drone swarms are incapable of applying common sense or adapting to new contexts based on cultural nuance and sensitivity. They're also incapable of reflection and reflexivity, or to apply human reasoning for making life and death decisions. Another significant gap concerns the moral integrity and intentionality in decision making. So machines are incapable, of course, of acting in good faith as some of the legal practices require. They lack any sort of faith or intention, and any ideas of individual responsibility are lost on them. From a victim's perspective, destruction by drone swarms is always arbitrary and meaningless, with limited avenues for accountability. So I believe these factors help to explain the role of drone swarms and other military technologies in the legitimation of the horrific violence we see in Gaza, at least by majority of Jewish Israelis who continue to support and actively serve in the military infrastructure. It adds to the growing dehumanization of Palestinians and contributes to the inaction of core international legal institutions. Now, before opening for questions, and I'm very happy to expand more on how all this applies specifically in Gaza, I just wish to note that while I'm native Hebrew speaker, But just like the drone lens, I feel that language can be a lens of and tool of dehumanization and control. And I feel that by discussing publicly the destruction of Gaza in Hebrew, I would take part in exercising domination and exclusion instead of partnership and equality. Thank you.
Thank you, Shiri, for this very devastating and fascinating account of the connection between law and technology and our cultural and legal practices. I see that we already have a few questions here. The first question posed by Ido targets the connection between the use of drones and the processes of dehumanization. You touched upon it, but maybe you can elaborate a bit on how it, gains grasp in public opinion and in the legal system, perhaps.
Sure. Thanks for the question. So in my work, I use a lot of case studies. Until recently, many of them were from context of other wars, including in Afghanistan. Some of them in the context of Gaza as well. And in many of the recent case studies that I worked on, we can see the effect of the drone lens on how humans are being perceived by military decision makers, including in targeting decisions. So partly, what we identify is that, and some of it, for example, I can share from a case study in Gaza from 2014, where an Israeli military investigation that ended through a court proceedings identified the mere use of drone lens and vertical type of detection of threat as the core reason for identification of children as Hamas operative. And one of the reasons that I found this, alarming in that particular case is that the military view was that, and they provided some experts that examined the evidence, and they all agreed that it was impossible for the decision makers in real time identified the children playing on the beach in Gaza as children, and that it was completely reasonable for them to identify the children as Hamas operatives because of the lens that was used to detect them, because it was a vertical lens that couldn't identify their height, for example, and because they were moving swiftly. However, if this is a limit or a limitation of that tool, it seems unreasonable that this is the tool that would be then selected as the main tool for threat detection, right? And so and I think that's the point that I was trying to make, that while drone lens can provide a lot of information for military decision makers, they also include inherent limitations of their scope, of what type of details they provide. And the result is that we get a very salient picture, an image that affects decision makers and requires an immediate response, but that still takes out of that picture, eliminate from that visual some important details, which ultimately makes it easier to identify anyone as a legitimate target.
Thank you. In this context, we have two questions here that I think I'll read together and you can discuss them. The first is Yali Khashash's question regarding the involvement of a human agent in the operation of drone. Where does it happen? At what stage, if at all? And the second question, Ayelet's question, concerns the possibility of shifting culpability from soldiers to programmers. Is that something that the law will take into account?
Great. So two very good questions. So first, with regard to the the role of human agents. So most of my research focused on human-machine interaction. So in all my case studies, I specifically look at how at kind of decision-making cycles where humans are the ultimate decision makers, something that may change in the future, but I think at least now is still the case. So you have drone operators or targeteers that this is their job and this is what they do. And in the majority of my work, I look at cognitive biases that are specific to human-machine interaction, and I look at how drone visuals affect human decision makers and affect how human decision makers interpret the information that they receive. So things like automation bias are included in that, and things like saliency bias, so the type of information. For example, if you receive some information in a form of a visual drone feed, that may distract you from other sources of information as it becomes more kind of, it captures more our attention. And the problem is that because the whole point of the drone swarms is that they can operate faster, stronger, with more information, human cognition just cannot cope. So the human in the loop ultimately remains an ineffectuate or ineffective way to provide some of the human advantages that we have as people. So the problem is that not only drone technologies have their own limitations, but they also trigger flaws in the humans that take part in this in a way that is currently providing more opportunity for destruction. Now, the second question about programmers, I actually don't find that idea attractive at all, because the problem is not the programmers or the developers. And having said that, I do have workshops with developers where, I try to kind of bring those issues up at the development stage. But the idea is not that developers will go to jail because, a drone swarm ended up killing civilians. The idea is that we will try to kill less civilians, or if possible, try to not kill civilians at all, right? And in some of my studies, I actually argue against this sort of individual criminal responsibility, or trying to point a finger towards individuals in that decision-making loop, where clearly those are errors that are not within a particular individuals. They are an organizational type errors that are generated and created through a system of decision making that is completely flawed. And so, pointing a finger to someone in that chain, may make someone feel better about it, but is not going to save the next civilians who are going to be killed in the same sort of way. So I think I think that pointing a finger towards developers is not going to solve most of the problems that we see in the field. And in a lot of those cases, what really needs to be corrected is the process and the system of the violence, in as a whole.
Thank you. We're reaching the end of the meeting, but there are a few questions, but I'd like to end with Regev Nathan's own question that kind of inverses the image of what you were speaking about now, and it concerns the drone's inability to detect intentions, I guess, the victim's intentions, and the ways in which this inability might affect the frame of justice that takes intentions into account.
So I agree with that point, and I think that in a system of drone swarms and destruction that's facilitated through drone swarms, intention, or mens rea, as in the legal jargon, or any sort of mental element is just not relevant anymore. And this is why I said I want to focus on this rather than on the legal definitions, because I feel that the way that decisions are being made today are completely, aside, and the problems of compliance with international law are aside to whether, how we should interpret the rules. The problems are in the way that we apply, the way that we make the decisions. And clearly in a system that's built on the necessity to identify intentions both at the perpetrators or with the victim, right, in the sense of who we target or the targeting process, it's just not relevant anymore at all. Of course, in a world where you identify risk through network analysis, through threat detection, probabilistic red flags, intentions have nothing to do with this. It's really about, who, has your number, whose calls you were, where did you, where your movements were detected, right? And things like that has nothing to do with your intention. And similarly, we cannot identify any sort of intention on the part of drone swarms that while they try to mimic human relationships or human communications, they clearly are incapable of having any sort of intention beyond, what is allowed or instructed through their programming.
Our time is up. Thank you so much, Shiri. It was fascinating and crucial to hear. Tomorrow, תודה לכולם. הצטרפו אלינו בבקשה מחר. אנחנו נארח את דוקטור מתן קמינר, שידבר איתנו על מהגרי עבודה מתאילנד ובא ולאחר השביעי באוקטובר. אז שוב תודה לכולם. תודה לך, שירי, ולהתראות.
תודה רבה.